Hello everyone, this is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to episode 360 of the FCPA Compliance Report. The FCPA Compliance Report is sponsored by the Doing Compliance Masterclass. If you have ever wanted to take one of the top classes on operationalizing your compliance program or doing compliance, this is the class for you. I just concluded a class in New York City, and it was an excellent class with lots of great interchange between the attendees. I keep the attendance limited to 10 people so that it becomes a true masterclass training experience for you. If you would be interested in my next one, I'll be posting the date and times for 2018 soon, so please contact me for details. Today I have back with me James Koukios. James is a partner at Morrison and Foerster, and he's also an ex-DOJer who worked in the fraud unit of the FCPA unit of the fraud section of the Department of Justice. We take a look at the recently announced FCPA Corporate Enforcement Program, which has been incorporated into the United States Attorney's Manual. It was announced Wednesday by Deputy Attorney General Rod Rosenstein. We take a look at three key components that James thinks were quite interesting or important. First is the recognition of declinations with disgorgement as a part of the DOJ settlement repertoire. We also consider the now presumption that companies will receive a declination if they meet the four criteria of the new policy, being self-disclosure, cooperation during investigation, extensive remediation, and profit disgorgement. We conclude with a discussion about the input that went into the new FCPA Corporate Enforcement Policy, how the pilot program presaged many of these, and the pilot program acted as a testing ground for these concepts. It's a fascinating discussion and exploration of this most significant FCPA development in 2017 to date. Thank you for listening to this episode of the FCPA Compliance Report. The FCPA Compliance Report is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, back for another episode of the FCPA Compliance Report. And this episode, we have a near emergency edition. And I have with me James Koukios. James is a partner in Morrison and Foerster, and we're here to talk about, I think, one of the most significant FCPA-related events or issues that have come up, certainly in the past few months, and that is the new announcement, or rather the announcement this week by Deputy Attorney General Rod Rosenstein of the FCPA Corporate Enforcement Policy that is now incorporated into the U.S. Attorney's Manual. So with that introduction, James, thanks for taking the time to hop on this. It's been a heck of a week in the FCPA and in Washington generally. So maybe if you could explain what the FCPA Corporate Enforcement Policy is, what the U.S. Attorney's Manual is, and then kind of give us your initial thoughts.
Sure. Thanks, Tom. Thanks for having me. So as you said, the big news this week was the Deputy Attorney General announced that the essentially FCPA pilot program that had been released last spring in 2016 in modified form was going to become permanent and was going to be incorporated into the U.S. Attorney's Manual. So one of the questions you asked, Tom, is what is the U.S. Attorney's Manual? And it's basically the policy document that guides prosecutors in the Department of Justice. Although it's called the U.S. Attorney's Manual, it really applies to everybody in the Department of Justice, whether you're in a U.S. Attorney's office or whether you're in one of the main justice components, like the fraud section, where the FCPA unit is housed. And so what happened was a little bit leading up to this, we'll set the stage, was last April, the fraud section chief, who was then Andrew Weissman, released a document that became known as the FCPA pilot program. And basically what it said was that for the next year, they were going to undertake a program under which companies that self-disclosed, fully cooperated, and fully remediated would be eligible for two kinds of relief. Number one, they may be eligible for a complete declination, or number two, if there was an enforcement action that went forward, they would be eligible to up to 50% off the sentencing bottom range of the sentencing guidelines. The other option was if you did not self-disclose, but you fully cooperated and fully remediated, a company would be eligible for up to 25% off the bottom of the sentencing guidelines range. One big caveat on that is if you were in that first category where you self-disclosed, cooperated, and remediated, and you were given a declination, it wasn't sort of the old-fashioned Morgan Stanley complete declination. It was a declination with disgorgement, which meant that you had to give up all the profits that were allegedly tied to the FCPA violation. And in practice, what that meant was that DOJ would publish a letter on their website saying, basically, this company paid a bribe and had disgorged X amount of dollars, but otherwise the department was declining to prosecute. In March of this year, so again, this was a program that was supposed to last for a year, and the ostensible goal of the program was to try to encourage companies to self-disclose by being more transparent on the benefits of self-disclosure. In March of this year, the acting assistant attorney general for the criminal division, Ken Blanco, who incidentally was one of my first bosses in Miami when I became an AUSA there, he announced that the pilot program was about to expire, but that DOJ was going to keep it in place while they evaluated its effectiveness. And then a couple months ago, over the last several months, Deputy Attorney General Rosenstein had said that DOJ was currently under the process of looking at a number of less formal policy documents that had been issued outside of the U.S. Attorney's Manual. They're going to be rethinking them and potentially revising the U.S. Attorney's Manual to reflect that thought. And the idea there is that sort of loose policy manuals are too hard for, I think the thought was loose policy memos and things like that were a little bit too hard to track. The U.S. Attorney's Manual, on the other hand, is a sort of a set document. It gets revised on occasion, but people know where to look. And we'd rather have the policies put out in that document that binds the entire department rather than have these kind of loose memos like the Yates memo or things like that. And so at the big ACI FCPA conference this year, the Deputy Attorney General used that as a forum to announce that that review had been conducted as far as the FCPA pilot program was concerned, that it was now going to become a permanent fixture of the U.S. Attorney's Manual with some revisions. And that has now been incorporated into the U.S. Attorney's Manual at Title IX, Section 47.120, called FCPA Corporate Enforcement Policy. And so what started out as a pilot program with some revisions is now an official part of the U.S. Attorney's Manual.
So quite a bit in there, some change, some clarification, some consolidation. From my perspective, a lot of good stuff. But this is not Tom's podcast on the change, because I really wanted to get your views. And you obviously worked in the fraud section, worked in the FCPA unit. Now you're in private practice, so you're representing companies. So what did you really see, James, as something that in your mind was significant, or something that you thought perhaps could have been done differently or even better?
Sure. So I think there's about three things that I want to point out, Tom. Maybe we can talk about each of those. Number one is the creation of a presumption of declination for a self-disclosing company. Number two would be the permanent fixture now of declinations with disgorgements. And number three would be sort of the process of how the evaluation period led to this new corporate enforcement policy. So if I could start with the first one, the pilot program, as I mentioned, the ostensible purpose of it was to try to incentivize companies to self-disclose. And it set out those two scenarios that if a company did fully self-disclose, as well as cooperate and remediated, it would be eligible for either a declination with disgorgement or 50% off the bottom of the sentencing guidelines. It wasn't entirely clear in the pilot program how you got to one or the other. And so I think one of the things that the new FCPA corporate enforcement policy in the USAM did was it said, look, if you self-disclose, we're going to start with a presumption that you will get a declination. And then it says the presumption can be overcome if there are certain aggravating factors. And those are things that you would probably recognize from other parts of the U.S. Attorney's Manual, like high-level management involvement, corporate recidivism, and other factors like that. And I think that's a real improvement over the pilot program. Not that maybe that wasn't in the pilot program, but it's much more clear in the enforcement policy that, look, if you self-disclose, we're going to start with the presumption that you're going to get a declination, and we're going to tell the community how that presumption can be overcome. It's these aggravating factors. Now, that doesn't end the discussion, because whether those factors are present or not are going to be open for debate when you go in to DOJ as a company. It may be your opinion, for example, that high-level management was not involved, and DOJ could have a different opinion, and so that may be one of the points of contention over the years that you're talking about this. But I think the overall structure is quite a bit clearer than the pilot program, and that change is very welcome. We've got the presumption, and then we've got explicitly some of the things that can overcome the presumption. So I think that's a big improvement over the pilot program, and I think that's going to be a welcome change for the legal and business communities in that regard.
James, I'm, as you know, came from the civil side of things. So my work and the criminal side of things is really observing, reading cases, talking to people like yourself. But I cannot recall any cases or any other areas where there's a presumption that a company will get a declination if they meet certain criteria, and starting with that they violated the law. Is my perception wrong? And if it's not, is this really a sea change for the Department of Justice?
I think your presumption is exactly right, Tom. And I think the new language in the revised USAM actually does talk to that fact. In the preamble for the new FCPA Corporate Enforcement Policy, it says, due to the unique issues presented in FCPA matters, including their inherently international character and other factors, the FCPA Corporate Enforcement Policy is aimed at providing additional benefits to companies based on their corporate behavior once they learn of misconduct. And I think that makes sense. If you haven't actually tried to prove an FCPA violation in court, which I've done, I'm fortunately one of the few people who have actually done that. It's very difficult to be able to get that evidence. It can be very difficult to get that evidence from overseas to prove one of these cases, because oftentimes the witnesses are unavailable to the prosecutor, the documents are unavailable to the prosecutor, because inherently in these cases, a lot of the misconduct takes place overseas. And so I think what the department is recognizing here is, look, given those challenges, we need to incentivize companies more to self-disclose. And so we have to give them a real carrot to do that. And I think that's why we start with, in the FCPA Corporate Enforcement Policy, starts with that presumption to give that carrot to the companies, recognizing the unique aspects of FCPA enforcement.
So what about the you mentioned declination with disgorgement. Once again, the first time I had seen that, at least from the Department of Justice perspective, was in the pilot program. And if I could step back, the pilot program, I thought, was very good as an example of something that was designed to be a pilot program, to see how things did work, to perhaps use that information to improve the program or going forward if it was decided to move forward. And that's one of the things I see in this new FCPA Corporate Enforcement Policy, James, that there were lessons learned from the pilot program by the Department of Justice, and they incorporated at least some of those in this new policy statement. And would the declination with disgorgement fall into that category in your mind?
So that's an interesting point, Tom. I really feel like my impression, my own personal opinion, was the actually biggest outcome of the pilot program was this creation of a new form of resolution called declination with disgorgement. The notion of giving companies additional credit off for good behavior and the notion of trying to explain when that credit will be given wasn't entirely new. Previously the department had tried to give that guidance through the enforcement actions themselves. The pilot program was a little bit unique in that it tried to put it into a policy document instead of just doing it piecemeal through enforcement actions, but the underlying concept wasn't that new. The declination with disgorgement was very, very new. And what it essentially says, the pilot program and now the USAM says, in FCPA cases, if we give you a discretionary declination, in other words, not one that's based on lack of evidence or lack of jurisdiction or the prescribed conduct because the statute of limitations has expired. If we're going to give you a discretionary declination, you're still going to have to cough up your illicit profits. And that to me was the biggest difference from the pilot program. Instead of just having guilty pleas, informations and indictments, or non-prosecutions and deferred prosecutions, we now sort of have a fourth category of resolution, which is declinations with disgorgement. And to me, I have to say, I understand how that is better than an NPA or a DPA, in that an NPA and a DPA has a detailed statement of facts. It has a detailed statement of corporate undertakings. There's usually a period where DOJ monitors your behavior, either through a formal monitor or through a self-reporting process. And so I can see why a declination with disgorgement is a better option for companies than an NPA or DPA, or obviously than a guilty plea. But the one big difference it had is, unlike the old declinations, these are made public. It's not so much the money itself, it's more the stigma. You are, in maybe less expansive language, but you are essentially, as a company, branded to be a bribe payer. And then that letter that brands you as a bribe payer is put up on DOJ's website for posterity. And so, one thing that I really wonder is, does that actually serve as an incentive for companies to self-disclose, or does it serve as a disincentive for companies to disclose? And I think that it's a very mixed incentive there, because I think a lot of good companies will say, well, maybe I'm better off just fixing the problem and having it go away, and having it go away with nobody knowing about it, rather than self-disclosing and then have this document put out there for quote unquote all time for people to see that we've been branded a bribe payer by the Department of Justice. And so what I would have liked, and this is kind of my third point, what I really would have liked to have seen the department do during the evaluation period is to go out to companies and ask them, did the pilot program actually provide the incentive that we had hoped for you to come and self-disclose? Or are there any parts of this that maybe unintended consequence provided a disincentive for you to come forward? Because I think it's a mix. I think some companies are going to weigh it one way, other companies are going to weigh it a different way. But I heard from a lot of people out there in the business community that they felt that the declination with disgorgement acted as a disincentive because of that public branding. And so it would have been, I think, prudent in this situation during the evaluation period to kind of reach out to the business community and ask them what their reaction was. It doesn't appear that happened. Maybe it did, and it just wasn't very public. But it doesn't appear that DOJ did actually go out and talk to the business community to learn about whether the pilot program gave them incentives or gave them disincentives.
So as kind of a commentator around compliance and someone who tries to not really read the tea leaves, but see which way, what best practices are, what evolving best practices are, one of the things I've asked for is to have information on declinations, and here I'm specifying declinations without disgorgement, a true declination, those facts made public. We saw that in the anonymized declinations that were put out in the 2012 guidance, and those give the compliance practitioner, I think, an excellent idea of what companies who may have sustained an actual violation. Nevertheless, because of the robust nature of their compliance program, their cooperation with the Department of Justice and other factors, received an entire declination, meaning one without disgorgement. But I guess from your remarks, James, you're a little more concerned about the effects on companies in consideration of whether they should even self-report.
I am. I think it's a valid point by some companies that this could actually be a disincentive because of the public stigma that comes with the declination with disgorgement. And look, these are difficult areas to work with. There's always trade-offs when it comes to policy decisions like that. I'm not saying this was necessarily the wrong decision by the government, but I think it would have been very helpful for them to go out there and solicit that kind of feedback from the business community to see what effect it had. You know, the interesting thing about those anonymized declinations in the guidance, Tom, is number one, the first one, anonymous declination number one, was actually my case.
Okay.
It was actually in the first 6 months I was at the fraud section. That was my case. Company self-reported, came in and told us, how they found out about it, what their reaction was to it, and what the remedial steps that had been put into place as a result of it was. And it was really impressive, what they had done. And so Chuck DeRoss, my now partner, my then colleague, this was before he took over as the head of the FCPA unit, we were very impressed by this company and what they had done. And we actually asked them, you did such a great job responding to this. Can we publish this? Because under DOJ policy, if you're not charged, DOJ policy is to not name you as being a wrongdoer. And so that carried over to declinations as well. If we were not going to charge you, we didn't want to put your name out there because there could be a reputational hit just from that. And the company said, thank you very much for that positive feedback, but no thank you to this getting published. And the idea there was, even though they had done the right thing and gotten the right message from us, the public stigma of having that reported was too much. And we respected that, obviously, and followed department policy and did not publish that. But that's kind of when I talk about the potential disincentives of declinations with disgorgement, that very much informs part of what I'm thinking. But the other thing is, I think you're right, Tom. I mean, the problem with that is then we lose some of the value of the lessons that company learned from a public perspective. And so how do you get that message out to the company or to the public if you're not making this public? And those anonymized declinations that were in the guide was actually in large part influenced by our meetings with the business community. And they expressed that. They said, look, we really want more guidance. We know you're telling us that you're declining things for policy reasons, but we're not seeing it. And we don't get any guidance from it. So we would like you to include in the guide examples of declinations. And that goes to the other part of my point there is that not only did we hear them about the one company about the disincentives of making these things public, but we listened to the business community about how the positive effect of at least describing in an anonymized fashion what the factors we were considering, how that played into a declination out there. And I think the guide really benefited from that interaction with the business community in that regard. And this seemed like the pilot program evaluation stage had the opportunity for that to happen again. And from what it seems, at least in the public record, I'm not sure how much of a interaction there was in that regard.
So, James, one thing I wanted to ask was in the very last section of the new enforcement policy entitled Civil Injunction Actions, there was language which talked about both the SEC and the Department of Justice obtaining civil injunctions. And certainly I was aware of the SEC obtaining injunctions as part of the remedies that they might utilize. But frankly, I was not aware that the Department of Justice either could or would seek a civil injunction against violations of the anti-bribery provisions by U.S. companies or foreign nationals. Is that something new, or is that something that you experienced when you were at the DOJ?
No, it's since the at least as far back as I know, DOJ has civil authority over non-issuers. So, and that's why if you take a look at the new, the revision here, about civil injunctive actions, it mentions 78 DD2, which is domestic concerns, and 78 DD3 is foreign actors that take action within the United States. SEC may not be able to reach them because they're not issuers, and so civil authority was given to DOJ for those two classes of subjects. Now, I think there may have been, I'm not quite in the weeds on this, as I know my partner Chuck DeRoss is, in terms of the FCPA history. I think back in the early days, there may have been an exercise of this discretion by DOJ, but ever since DPAs and NPAs have been an enforcement tool, DOJ really has not really used its civil enforcement authority, and instead has used its criminal enforcement authority to do things like NPAs and DPAs. And it's not an injunction insofar as obviously saying thou shalt not violate the law again, but essentially when you're saying we're going to give you a DPA or an NPA for 2 or 3 years, you are essentially saying I'm not going to violate the law for 2 or 3 years or else there'll be penalties. So long story short is DOJ's long had this civil injunctive authority, but rarely exercises it and instead uses the DPA and NPA tools as a substitute.
Well, that certainly explains it for me. Well, James, I wanted to thank you, and I've been visiting with James Koukios. James is a partner in Morrison and Foerster, and we've been talking about the recently announced FCPA Corporate Enforcement Policy by the Department of Justice. James, thank you, and I look forward. This is something I think we're going to be looking at for quite some time. Hello, everyone. This is Tom Fox again. I'd like to thank you for listening to this episode of the FCPA Compliance Report. If you have listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings. Also, if you have any questions on this or the new Department of Justice FCPA Corporate Enforcement Policy, please give me a shout at tfox@tfoxlaw.com. Thank you again for listening to this episode of the FCPA Compliance Report, and I hope you'll join me again next week for another episode. The FCPA Compliance Report is a part of the Compliance Podcast Network.